Good morning, everyone. It looks like a bunch of folks are filing in. Thank you all for being here. We'll just give it another 30 seconds or a minute or so, so that everyone can get in from the waiting room. All right, it looks like everyone has made it in. We'll get started. Welcome to the 33rd installation of the Panetch Training Academy. Today, we'll be giving you a case law update on intellectual property cases that happened over the past year or so. I am Keith Jones. I'm a counsel at the firm. I spend most of my days doing IP litigation of all sorts. Joining me today is my colleague, Juliana Hunt. I will pass it over to her to let her introduce herself.
Thank you, Keith. Hi, guys. I'm Juliana Hunt. I'm an associate here in my first year at Panetch Schwarzy. I have a chemical background, so I handle patent prosecution in the chemical field, as well as I do some patent and trademark litigation matters. So just a reminder before we get started here today, this session is being recorded and it will be available on our website tomorrow. Feel free to ask questions in the chat or during the Q&A and the Q&A option at the bottom of the screen. And we'll be keeping a close eye on those and try to answer throughout the presentation. And then for those of you seeking CLE credits in Delaware, Georgia, Pennsylvania, or Virginia, please make sure to just stay on for the full session and answer the pop-up polls and then fill out the feedback survey at the end. So I think without further ado, we can dive straight into the first group of cases, which is trademark cases. Thanks, Keith. If you could just, thank you. Awesome. So our very first case is Vidal versus Elster. Okay, so after Trump was elected for the first time in 2016, a man by the name of Steve Elster sought to register the trademark Trump Too Small. And on the next slide, we'll show a picture of this, what I'm referring to. But basically, the word mark Trump Too Small was accompanied by an illustration of a hand gesture. And Elster wanted to use this on clothing merchandise like hats and shirts and things of that nature. And then also just for a bit of background context, the Lanham Act is the federal trademark statute in the United States, and there's something called the Names Clause, which essentially prohibits federal registration to any trademark which includes the name of a particular living human being without their prior written consent. So the consent must be written, and the purpose of the Names Clause is basically just to prevent consumers from being misled or confused as to whether that human being is associated with the goods or endorses the goods and the services used with that trademark. So here, the USPO initially refused trademark to Elster's application, finding that it was in violation of the Names Clause, of course, because President Trump had not given written consent beforehand. And then Elster appealed this to the PTAB, arguing that the Names Clause infringes his First Amendment freedom of speech rights. But the PTAB affirmed the USPO, and then Elster again appealed to the Federal Circuit, which actually reversed finding for Elster and saying that the Names Clause, in fact, did violate his First Amendment rights. So then if we go to the next slide, you can see here, this is the word mark Trump Too Small, along with the hand gesture that Elster sought to have federally trademarked. And then if we head to the next slide, so the legal issue here precisely that the Supreme Court had to answer was pretty simple. It's just whether or not the Names Clause violates the First Amendment. And essentially here in First Amendment jurisprudence, speech restrictions fall into two categories. They can either be content-based or content neutral. And here this was a content-based restriction because it limited the speech based on the content or the subject matter that was being conveyed. And these restrictions are highly suspect and usually are found unconstitutional, but they have to meet the strict scrutiny standard of review. So basically what that means is that the government has to show that there's a compelling government interest and that the law or the restriction on speech is narrowly tailored to serve that interest. So the Supreme Court here reversed the Federal Circuit and found that though the Lanham Act's Names Clause is technically a content-based restriction on speech, It didn't violate the First Amendment here, and it was held to be constitutional. And the court really found two compelling government interests. The first is protecting that name individual's rights. So in this case, the first compelling interest here was to protect President Trump's rights in being referred to in that trademark without his consent. And then the second interest is, again, just protecting consumers from being misled or deceived about the source of the goods and the services. And just as a final note, the Supreme Court also, found the constitutionality of the names clause here by honing in on the fact that this is a viewpoint neutral restriction on speech, meaning that it doesn't favor one message over another, and it doesn't discriminate based on opinion. So just again, the holding here was that the names clause is constitutional and doesn't violate the First Amendment.
The Supreme Court also in the past year or so had a second trademark case. This was Dewberry Group versus Dewberry Engineers. And as you can probably guess right from the case title, it was a trademark dispute over the word Dewberry. Justice Kagan had a moderately funny aside in the opinion. She said the success of John Dewberry's overall business comes in part from trademark infringement, specifically from Dewberry Group's violation of Dewberry Engineers' trademark rights in the Dewberry name. And then parenthetically, if that sentence is confusing too darn many Dewberries, it is also a good illustration of why trademarks exist, to prevent consumers from being confused about which company is providing a product or service. And so the issue here was that Dewberry Group was sort of a central hub of a commercial property enterprise, and it had a bunch of related companies also owned by Mr. Dewberry that each owned a piece of land and leased it out. The Dewberry Group in the center was essentially the operations component. It sort of did all of the logistical and the financial and the legal things. As a result, because the rental income went to the separate companies, Dewberry Group in the center operated at a loss. Dewberry Engineers had a federal registration for the Dewberry mark, sued, and liability was very easily established. Obviously, it is the exact same name, and it was even willful infringement. The issue came up because the Lanham Act allows you to disgorge the defendant's profits as a financial remedy. And the central entity of the Dewberry Group had no profits. So the district court decided to just rope in all of the profits from the related entities and treated them as, quote, a single corporate entity, despite not analyzing any doctrines like piercing the corporate veil. The Fourth Circuit Court of Appeals affirmed, although one judge dissented. It said it wanted to avoid a blueprint for using corporate formalities to insulate infringement from financial consequences. The dissenting judge essentially said that's all well and good, but you can't just tack on the revenues of non-parties. So the Dewberry Group appealed to the Supreme Court, and unanimously they said that defendant in the statute means exactly what it says, defendant, the party named in the lawsuit. It had a lot of sort of couching language to say that, the concern for these sort of corporate shell games is not amiss, and that there may be plenty of ways to award the profits of the related entities to the plaintiff in such a case. But essentially, the plaintiff did not do what it should have and either argued to pierce the corporate veil or pretty simply just name the other defendants. So Justice Sotomayor also wrote a concurrence with even more ideas to essentially give the plaintiff a blueprint for going back on appeal and trying to fix its error. I personally, as a lawyer, am a little bit concerned about the plaintiff's counsel's potential liability here for not suing the correct entities. But the case is still pending. We will see how things play out. The parties opening supplemental briefs on the issues are due at the Court of Appeals next week. So if anything interesting comes out of this case, further, we'll send out an email with an update. But the gist of the Supreme Court's decision here is just that to disgorge a defendant's profits, the statute means what it says. Defendant is the defendant in the lawsuit.
All right, so we're moving on to our next group of cases, which is patent cases. And our very first one is Amarin Pharma versus Hikma Pharmaceuticals, and this is a Hatch-Waxman Act case. So for those of you who don't know, the Hatch-Waxman Act was enacted in 1984, and it essentially provides a streamlined process for generic drugs to gain FDA approval. So generic manufacturers submit what's called an abbreviated new drug application, or an ANDA, with the FDA seeking federal approval of their generic version of the drug. And if the generic manufacturer seeks approval of a drug which has indications or uses which are still patented, then the generic manufacturer also submits what is called a Section 8 statement, which basically asserts that the generic label does not cover any of those patented uses or indications. So as you can imagine, because those patented uses are omitted from the label, it kind of carves out those uses from the label and thereby renders it a skinny label. So it's often called a skinny label in the industry, if you've heard that term before. And then also just wanted to delve a little bit into induced patent infringement here because it's of particular interest in this case. Induced patent infringement basically requires a person to have knowledge of the patent as well as an intent to induce infringement of the patent. So for this usually arises in cases when someone actively encourages another party to directly infringe the patent. So for a generic manufacturer, for example, if the generic manufacturer encourages the use or instructs physicians to use the drug for a still patented use or indication, they could face liability for induced patent infringement. So with that background in mind, if we head to the next slide, we'll see the parties in this case. So here, Amarin is the brand name manufacturer, owns two patents, the 537 and the 861, both of which are directed to methods for treating severe hypertriglyceridemia, which I'll just refer to as SH, as well as other cardiovascular diseases. And they have the brand name drug Vascepa. And then our generic manufacturer here is Hikma, and they filed an ANDA seeking approval of the generic version of Vascepa, along with a Section 8 statement that essentially carved out the patented use for treatment of SH. So even though they submitted a skinny label, Amarin sued Hikma, alleging induced patent infringement and asserting that Hikma, even though it carved out the patented use for treating SH, Hikma was actively encouraging use of its generic drug for treatment of SH and the other patented cardiovascular indications. Amarin specifically pointed to several press releases that Hikma had sent out, which promoted a generic, as well as its website content, which all of which referred to Hikma's product as the generic version of Vascepa. Also, they cited sales figures of Vascepa in the marketplace and basically just advertised the drug as a treatment option for SH. So the District Court of Delaware did not find this persuasive and did not find that Hikma actively induced infringement, and that its skinny label alone, because it carved out the indicated use, that Hikma could not be liable for induced patent infringement here. However, Amarin did appeal the case to the Federal Circuit Court of Appeals. So on the next slide, the Federal Circuit was tasked with specifically asking whether or not a generic manufacturer can be held liable for induced patent infringement, even if it submits this fully carved out skinny label, but also engages in commercial conduct or encourages or directs physicians and others to use the generic for a patented use. And the Federal Circuit held yes, and this was a pretty intense decision for the Federal Circuit here because there was no direct evidence showing that Hikma in any way actively instructed or encouraged physicians to prescribe its generic for treating SH. But the Federal Circuit found that taking the skinny label in addition to Hikma's public statements, the press releases, the constantly referring to Vascepa's sale market, as well as just information on its website, that it could be used for treating SH and other cardiovascular diseases, that this did rise to the level of induced patent infringement. So just a couple of practical pointers here. HICMA did file a petition for cert. It's still pending before the Supreme Court, so we're not sure yet whether the Supreme Court will take it up. So right now, the Federal Circuit's opinion is sort of the law of the land in this area. So for that reason, I would just like to point out that generic manufacturers should really take caution here, because even if a generic manufacturer submits a fully carved out Section 8 statement with its ANDA, they can still be subject to liability if they take, even passive commercial conduct, which refers to the brand name drug or says that the generic drug can treat those patented uses.
Our next case is LKQ Corporation versus GM Global Technology Operations. We actually touched on this case a little bit in our presentation at the beginning of last year on design patent infringement. But since that presentation, the Federal Circuit issued an en banc opinion in this case, the first time it issued such an opinion in 6 years. So it was somewhat big news for us in the patent world. And as you probably could guess based on my introduction, the case revolved around a design patent. GM, General Motors, owned a patent that covers the design for a vehicle's front fender that was used in the Chevrolet Equinox. LKQ filed a petition for inter partes review, arguing the design was obvious over 2 prior references, and the PTAB found for GM under what we call the Rosen-Durling test, because there was significant differences overall between the base reference and the patent. The Federal Circuit affirmed, and the issue here is that for utility patents, anyone in the patent world knows that we look at obviousness based on the Graham v. John Deere test, and as the Supreme Court kind of reiterated in the KSR case in 2007. But somehow over the years, the jurisprudence on obviousness for design patents led us to a different test from the 1980s called the Rosen-Durling test. And the Federal Circuit panel ruled based on that Rosen-Durling test because it was at least arguably the law of the land for design patents. But the Federal Circuit granted rehearing to decide whether that's actually true, because in 2007, the Supreme Court's KSR decision came out. Here's just a quick example of what the patented design and the 2 prior art references look like. They all look fairly similar to me. So moving to the legal standards, the Rosen-Durling test came out in 1982. It requires you to identify a primary reference with a design that is basically the same as the challenge patent's design, and then you can tack on supplemental references that are related to the primary reference, such that the ornamental features in one reference suggest application of those features to another. But in the interim, in 2007, the Supreme Court took up obviousness for utility patents in the KSR case. It rejected the Federal Circuit's rigid interpretations of the Graham v. John Deere factors from 1966, and said, no, there's no rigid formulation. There's just 4 factors to look at, and you weigh them all, and the fact finder makes a decision. Those factors are the scope of the prior art, the differences between the invention and the prior art, the level of a person of ordinary skill in the art, and then objective indicia of non-obviousness, such as commercial success of the patented invention. And so last May, the Federal Circuit put out this big en banc decision and said, let's get rid of the Rosen-Durling test. That is not good law in light of KSR. And so obviousness of a design patent gets the same treatment as obviousness of a utility patent. You apply the Graham v. John Deere factors and go from there. And you look at the overall picture and you weigh those factors. And just some practical pointers. This decision is already having big impacts in design patent prosecution and litigation, because the more flexible framework allows more easy application of obviousness rejections during prosecution and obviousness invalidity arguments during litigation and in inter partes review proceedings.
All right, so our next patent case here is Celanese versus ITC, International Trade Commission. So Celanese here is a global chemical company which owns two patents of interest here, the 247 and the 163, both of which are directed to methods or processes for manufacturing acesulfame potassium, which is also called ACE-K and is a well-known artificial sweetener. So both of these patents are actually designed to improve efficiency, yield, and just the overall environmental stability of ACE-K production. And then another player in this case, particularly, is the ITC, which, as many of you know, is a federal agency that has authority over U.S. imports and also investigates IP infringement and other unfair trade practices. And then finally, Jinhe is another party involved in this case, which is a Chinese manufacturer of fine chemicals and food additives, and they also manufacture ACE-K. And has a U.S. affiliate that imports its products into the United States. So this case originally arose when Celanese filed a complaint with the ITC, alleging that Jinhe's U.S. affiliate infringed the 247 and the 163 patents by importing ACE-K into the United States. Basically, by filing this complaint with the ITC, Celanese argued that the products were made using the processes that are patented in the 247 and the 163, and Celanese sought to block Jinhe's importation of ACE-K into the United States. So during the ITC proceedings, Jinhe actually moved for summary judgment based on invalidity of the patents and argued that the on-sale bar, which I will show the text of on the next slide in just a minute, they argued that the statutory on-sale bar rendered the two patent methods not eligible for patent validity because they were commercially available or offered for sale more than 1 year prior to the patent application filing date. So on this slide, you'll actually see two dates, the first of which is September 21st, 2016. That is the effective filing dates of both of the Celanese patents. And then this critical date for on-sale bar purposes is 1 year prior to that, so September 21st, 2015. So just keep that in mind as we move forward with this case here. So again, Jinhe argued that these patents were invalid based on the Section 102A1 on-sale bar. And the ITC administrative law judge actually found in favor of Jinhe and held that the Celanese patents were invalid as barred under the on-sale bar of Section 102. And the judge basically found that these pre-critical date sales before September 2015 of ACE-K triggered the on-sale bar and therefore invalidated any patents that Celanese sought to claim directed to those methods for producing ACE-K. So if we head to the next slide, this is just again a snippet of the statutory language. So here you can see that the claim dimension, if it's on sale or in public use before the effective filing date, then the statutory on sale bar is triggered and any of those claims are barred from patentability under Section 102. So then if we go to the next slide, this case was appealed up to the Federal Circuit, and the Federal Circuit had to determine whether pre-critical date sales of products that are made using secret or undisclosed processes are still sufficient to trigger this on-sale bar under the AIA, and therefore invalidate any later sought claims to those patented methods or processes. So basically here the question was whether sales of ACE-K made using those processes embodied in Celanese's patents were sufficient to trigger the on-sale bar. And the court held that yes, that was sufficient even if the products were made by secret or undisclosed processes and methods. Celanese here essentially argued that the term claimed invention in the statute only refers to the explicit subject matter of the claim. So Celanese was arguing that because the processes themselves weren't available publicly or on sale prior to the critical date, that the on sale bar was not triggered. But the Federal Circuit really just rejected this interpretation of the statute and found that even the sales of the end products of the ACE-K, which were derived from those undisclosed processes occurring before the critical date, was sufficient to trigger the on sale bar and invalidate the later process claims. And the Federal Circuit really relied on a prior Supreme Court case, which many of you might be familiar with. It's called Helsin Healthcare versus Teva. And in this case is notorious for its holding that secret sales of a claimed invention do trigger the on sale bar, even if it's, a secret sale and it's not technically super publicly disclosed or any of that. So because secret sales of a claimed invention can trigger the on sale bar and therefore invalidate later patentability of that product, the court really applied that reasoning here too, in the context of a later sought patent claim as well.
It looks like in the chat, there's a little bit of confusion about the CLE polls. The first poll was labeled as poll number 2, and it appears that there was some confusion there. I think we can get all of that straightened out. Moving on to our next case. The next case is EcoFactor v. Google. This one is potentially going to have some big implications in patent infringement litigation damages. It is scheduled to trigger the Federal Circuit's next rehearing en banc. So as that proceeds, we can, again, keep everyone updated if anything interesting comes. But here's where we are so far. It's an issue relating to the admissibility of expert testimony on damages. And as you may know, Federal Rule of Evidence 702 was tweaked in recent years as part of an effort to get judges to take their gatekeeping role a little bit more seriously. And so, as you probably also know, that 702 is applied in the courts under the Daubert standard, which governs admissibility of expert evidence based on testability, peer review and publication, error rate, standards of controls, and general acceptance of the methodology. The background for this case is that EcoFactor owns a patent for smart thermostats. It sued Google for the Nest thermostat product. That happened in the District Court for the Western District of Texas. And the damages testimony came in a somewhat interesting format. There were 3 prior license agreements that the damages expert wanted to rely on. They each had a lump sum license fee, and the expert wanted to be able to take that and turn that into a per unit rate that he could apply to the Google sale products. To do that, he relied on the testimony of the CEO of the plaintiff to say, essentially, here were the number of products at issue for each of those 3 prior licenses. And so from that, you can calculate the per unit royalty. The problem was the CLE, due to confidentiality restrictions, did not have access to the other party's actual sales in those instances. He was just using sort of public market data and things like that to come up with his best estimate of the licensee sales. And so Google argued that that was not sufficiently reliable, that they were essentially fictional made-up numbers. The Texas court did not find that persuasive, so it went to trial. The jury awarded $20 million in damages to EcoFactor, and naturally, Google appealed. Among other issues in the appeal, it raised this same argument that the damages expert's testimony never should have even been presented to the jury because it was unreliable and not based on real data. And so that is the issue that the Federal Circuit considered. It affirmed the decision, although it was a divided panel. Judge Prost dissented and was very skeptical that the assumed or estimated per unit rate had any actual tie to the real sales. And so based on that, I think Google sees its opportunity. Whenever you see a dissenting judge in your panel, you might have a shot at rehearing en banc. So they filed their petition. And the Federal Circuit is going to consider that specific issue. Oral arguments were heard in March. So two months have gone by. I would expect a decision to come out in the next few months. And hopefully it will be enlightening on the admissibility of expert testimony going forward. It is always a bit of a fine line if you're the plaintiff to have your expert rely on prior licenses. So hopefully this will give us more clarity rather than more confusion, but we will see. So the practical pointer there is just be very careful when you try to apply prior licenses to a present litigation.
All right, so we've made it to our last patent case for the day. This is SnapRays versus Lighting Defense Group, and it just deserves a brief mention here, but it involves something, we're probably all involved with on a day-to-day, which is Amazon. So for those of you who don't know, Amazon actually has a program called Amazon Patent Evaluation Express Program, or APEX. And essentially this program can be used for easily resolving patent disputes when, namely claims of patent infringement against Amazon sellers. So the APEX program works as follows. The patent owner will submit an APEX agreement to Amazon, which basically identifies the allegedly infringing claims of the patent and then lists any Amazon listings which are alleged to infringe those patents. And then subsequently, Amazon sends that APEX statement to the Amazon seller directly, who has several options. The first is just, to remove the accused listing. The second is to opt into this APEX program and essentially let a third party determine whether or not there's patent infringement. The Amazon seller can also just resolve the claim directly with the patent owner or pursue the more litigious option and file a lawsuit for a declaratory judgment of non-infringement. So that's actually what happened in this case, the fourth option. Here, the patent owner, Lighting Defense Group, or LDG, filed an APEX statement with Amazon alleging that Snap Power sells electrical outlet covers on Amazon. And so the APEX statement alleged infringement of LDG's 347 patent. So like I said, Snap Power here responded with the litigious option and filed a lawsuit for declaratory judgment of non-infringement in the District Court of Utah. And so as you'll see here, I have a little bit of background. This case implicates a little bit of civil procedure and personal jurisdiction. So before we head to the next slide, I just want you to keep in mind that LDG here is a Delaware company, which has a principal place of business in Arizona. And Snap Power is totally a Utah company with principal place of business in Utah as well. So LDG filed a motion to dismiss in the District Court of Utah for lack of personal jurisdiction. LDG argued that because it was domiciled technically in Delaware and had its principal place of business in Arizona, that it could not be subject to personal jurisdiction in the District Court of Utah. And the District Court of Utah, found this persuasive and found for LDG, granting the motion to dismiss, saying that LDG was not domiciled in Utah and also did not purposefully direct its activities at Snap Power in Utah, and therefore did not purposely avail itself of Utah or have minimum contacts with Utah to make personal jurisdiction sufficient there. So if we head to the next slide, this is a screenshot of Amazon where Snap Power was selling the allegedly infringing electrical outlet cover. Okay, and then if we head to the next slide, So in the United States, in order to file a lawsuit, a plaintiff has to demonstrate that the defendant is subject to personal jurisdiction in the forum state. And this can be accomplished by general personal jurisdiction or by specific personal jurisdiction. And specific means that the defendant's activities in that state are related to the claims and the lawsuit at issue. So in order to have specific personal jurisdiction over a defendant, there must be three requirements that are met. First, the defendant has to purposefully direct its activities at a resident in the forum. The claim in the lawsuit has to arise out of or relate to the defendant's actions in the forum state. And then, of course, asserting personal jurisdiction has to be reasonable and fair, and therefore comply with due process. So the specific legal issue in this case was pretty simple. It's just whether or not the specific act of filing that apex agreement subjects a patent owner, like LDG in this case, to specific personal jurisdiction in the state where the alleged infringer resides, if and when the alleged infringer later decides to file a declaratory judgment suit. And so here the Federal Circuit held that yes, that is sufficient. And with respect to the first factor of those three factors in specific personal jurisdiction, the court found that LDG did purposefully direct its activities at Snap Power in Utah because it knew that by filing that apex agreement, Amazon would eventually inform Snap Power that it had several options, one of which would be to just remove the listing from Amazon or to seek a declaratory judgment action of non-infringement, both of which would essentially affect Snap Power's business and its activities in the forum state of Utah. So the Federal Circuit found that this was enough and that all three requirements were met, and therefore LDG could be held to have personal jurisdiction in the District Court of Utah. So that is our final patent case. And we're going to head to the world of copyrights next. And I'm going to tackle the first copyright case as well. The first case is Thaler versus Perlmutter. And many of you might be fairly familiar with Dr. Stephen Thaler. He's pretty notorious in the IP space. He is a computer scientist and entrepreneur. He made headlines first in the Thaler versus Vidal case, which the Federal Circuit basically found that Thaler tried to have his AI machine called Davis named as the sole inventor on a patent application. And the Federal Circuit held that inventorship under United States laws is limited to natural living human beings, and therefore that his AI system could not be listed as the sole inventor on that patent. So then again, he tried with copyrights as well. In May of 2019, he applied for a copyright on a 2D creation called A Recent Entrance to Paradise. And we'll actually show that on the next slide. But this piece of artwork was created entirely by his AI system named Creativity Machine. And even on the copyright application itself, Dr. Thaler listed that Creativity Machine was the sole author, that there was no other, human or no other involvement in creating this artwork. So the US Copyright Office outright rejected Thaler's copyright application on the basis that copyright protection under the US laws requires some human component, some human authorship. And the District Court of DC upheld on the same grounds, basically saying that because there was no human involvement in creating this artwork, there was no copyright eligibility. So if we go to the next slide, we can actually take a look at the artwork. So this is a recent entrance to paradise, which was again created entirely by Thaler's AI machine called Creativity Machine. So if we go to the next slide, the precise issue here for the DC Court of Appeals was whether or not creative works that list an AI machine as the sole author can qualify for copyright protection, or whether or not a human is also required. And in a unanimous decision, the DC Circuit Court affirmed the lower court's decision and echoed that same sentiment from the Thaler versus Vidal opinion and interpreted the statutory text of the Copyright Act. So although the Copyright Act does not explicitly define what it means to be an author, the court looked to other statutory provisions within the Copyright Act to say that, a copyright requires some sort of human involvement. And both of those things were first and foremost that property ownership is inherently tied to human capacity and therefore it can't really be applied in the same context to a machine. And second, which I thought was a very creative argument, is that copyright duration is linked to the life of the author and it depends on, the death date of the author of the work. So again, this kind of drives home the fact that you can't have an AI machine be the sole author of a copyright because it doesn't die like a natural living human being would. So again, just as a note, the court here echoed its earlier decision in the Thaler versus Vidal holding with respect to patent rights, but applied that here in the context of copyrights as well. So again, under US laws, only human inventors and authors are subject to patent and copyright protection, and that AI machines cannot. But I would like to note that this doesn't completely rule out the possibility that works generated by AI can be copyrightable. It's just that in those narrow instances where the AI machine is the only author or the only inventor listed on these applications, that those works and those inventions will not be eligible for protection under US laws. But as long as you have at least one human inventor or one human author listed on those applications, you should be good to go.
Based on his history, I guess the next thing we'll be looking for is to see what happens when Dr. Thaler tries to register for a trademark in the name of an
Trademark,
AI.
right? Yep.
Sticking with the copyrights, it is a bit of a hot time for copyrights. This next case is White Monkey Productions versus Netflix. It's got a bit of a confusing backstory that pulls in a lot of aspects of pop culture. But I will go in the opposite direction and start in the most boring place, which is the statute itself, which is long and dry, but there's multiple sections that are going to come into play here. So I wanted to start there. Fair use is a doctrine that allows someone to take someone else's copyrighted work and use it without permission under certain circumstances. And so I've underlined a section in the preamble that says that you can do so for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. That will come into play later. And the other part that I've underlined is the first of the four factors, which is the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. So to continue the backstory, 2 years ago, the Supreme Court ruled on a case involving a pretty famous image of Prince. And it was specifically ruling on that first factor. And I'll show it to you again, the purpose and character of the use. And so what happened here was that a photographer, Ms. Goldsmith, was a pretty famous rock and roll photographer, took this iconic image of Prince and licensed it in 1981 to Vanity Fair magazine to use in an article on the musician. The license agreement specifically said, Vanity Fair, you can use this one time and one time only. And in doing so, Vanity Fair decided that their use was going to be to hire Andy Warhol, a famous artist, to do what I believe is called a silk screen, which is of the type of image that you see on the left, where you take the original image and you do certain things to it to kind of wash out the middle colors and things like that, and you get a sort of a stylized version of the original. Andy Warhol decided to then create 15 more silk screens of the image and use them for various purposes. And one of those purposes was on the cover of another magazine published by Vanity Fair's parent company in 2016. Naturally, Ms. Goldsmith was not very happy about that. She sued And the issue went all the way to the Supreme Court, who ruled specifically on the first fair use factor, and emphasized that the question under that factor is, what purpose is the copying being used for? And in this instance, it found on that factor to rule for the photographer against Andy Warhol and the magazine, because in both instances, the art was being used for commercial purposes and specifically for, magazine publication. And so even though there was a quote new expression in the altered image, it was still for essentially the exact same purpose. So that on that factor, it weighed against fair use. So that is the background to the current case, which is one of the probably the biggest case interpreting the Supreme Court's new interpretation of that factor. And the facts in this case are in the popular Netflix show Tiger King from 2020. There were 8 video clips that were used that were taken by a cameraman named Timothy Seppi. He sued for copyright infringement because he didn't authorize the use of those clips. For 7 of the clips, Netflix argued that they were works for hire, and therefore that Mr. Seppi did not own the copyrights to the videos. For the 8th clip, which he did own the copyright for, there was really no dispute there. Netflix raised a fair use defense because the clip, it was showing the funeral of Joe Exotic's husband. And I'll get to the specific arguments it made there in a second. The court on the first 7 videos agreed that they were made for hire, and those mostly kind of went away. They were not super disputed. The interesting one is the 8th clip, and Netflix argued that it was fair use because by just taking a clip of the overall video, it was transformative, and by incorporating that into the documentary, it was just doing essentially factual coverage of this funeral. And it was only a small portion of the video, a small portion of the documentary series, and it was interspersed with commentary related to the broader narrative. The district court agreed with Netflix, and it went up on appeal. The 10th Circuit Court of Appeals panel reversed on that one video for the fair use purposes. And it spent a lot of time analyzing whether the copied use was satire. And it raises a sort of a fine line between satire and parody, based on whether the clip being copied was used as a commentary on itself or on something else. And in this instance, it was the court noted that Netflix was not using the clip as a commentary on the original work. It was essentially just using the original work itself. And so considering that, it looked to that first factor and what is the purpose that it was being used for. Oh, it looks like the CLE poll popped up again. Everyone make sure you click on that if you need your CLE credit. The other issue that came up relates back to that preamble, and I'll scroll back to that. Oops. Netflix, even though it doesn't specifically say documentaries, Netflix argued that documentaries fall under these purposes listed in the preamble of the fair use statute, and therefore that its use would be fair use. I think the Court of Appeals was caught a little bit in a bind here. It's the briefing on the original appeal was complete before the Supreme Court's decision in Warhol came out. The parties did some supplemental briefs under, kind of the new authority issue, but those were kind of quick and limited. And the 10th Circuit Court of Appeals issued its opinion, and then a little while later, essentially said, "Never mind, we vacate that. Please give us more supplemental briefing," largely directed to the preamble issue and um, the first factor under the fair use statute. So this is another one where the issue is sort of outstanding. The supplemental briefing, so to say, has been filed. The Court of Appeals, I guess, is considering it. We will see, and it is an on-bank review in the 10th Circuit, and so we will see what comes out of that. It should be enlightening because it's really the first big interpretation of the Supreme Court's restatement of the standard under that first factor of fair use. So I'll pass it back to Juliana.
Yes, thanks, Keith. So the next case that kind of addresses the same copyright infringement fair use world actually has to do with tattoos, interestingly. So in this case, in 2017, a legendary tattoo artist named Catherine von Drakenberg, or just Kat Von D, she tattooed a picture of the famous jazz musician Miles Davis onto her friend's arm. Her friend's name is Mr. Farmer. And in doing so, she used a photographic copyrighted portrait of Miles Davis that was taken back in 1989 by a man by the name of Jeffrey Sedlick. And I'll show those the side by side on the next couple slides and all of that. But just for the time being, this is just Kat's background. And after finishing the tattoo on her friend, Kat took to Instagram and she posted photos of her original trace of the Miles Davis photograph, and then a side-by-side comparison of the finished tattoo on her friend's arm. And then in February of 2021, Sedlick actually sued Kat for copyright infringement, arguing that the works, the photograph, the original photograph, and the tattoo were substantially similar, that the extrinsic and the expressive elements of the work were very similar. They shared a total concept and feel, and therefore he alleged that she infringed his copyrighted photograph. And then in return, Kat raised the defense of fair use, basically arguing that she had sufficiently transformed the original copyrighted photograph, especially because it had new expression and meaning as a tattoo, and it sort of had a personal meaning to Mr. Farmer that was not the same meaning as the original copyrighted photograph had. So a jury sitting in the Central District of California returned a verdict in favor of Kat, finding that there was no copyright infringement in the Miles Davis tattoo because Sedlick essentially didn't demonstrate that the two works were substantially similar. And also, the social media Instagram posts that Kat posted to the world of her tracing the photograph were protected under this doctrine of fair use. So if we head to the next slide, we can take a minute to see a side by side. So here on the left is the photograph, the copyrighted photograph that Sedlick took back in 1989. And then on the right-hand side is the tattoo, the Miles Davis tattoo. And just personally, it looks quite similar, but there's different things going on. It's a tattoo for one thing. It's not necessarily another piece of art, digital or on paper. And there's shading differences. There's quite a few differences. And then if we head to the next slide, this is the Instagram photo that was at issue in this case. This is Kat on the left, you can see, and she's tracing photograph as she's preparing to tattoo it on her friend's arm. Okay, so heading to the next slide. So the legal issues here, this case is actually on appeal at the Ninth Circuit. The Ninth Circuit has not yet issued a decision. So all we have for the time being is just the jury verdict and then the district court opinion that came out. So I just do want to discuss that a little bit because it gives us some guidance here on this topic. So essentially the issue was whether that secondary work of the tattoo that involves an artistic interpretation of the original photograph, such as, by adding that shading or making it look different as a tattoo on a person's body, whether that constitutes fair use. And in California, the standard for transformativeness and for substantial similarity requires a two-factor approach. It looks at the extrinsic similarity and the intrinsic similarity. So the extrinsic just, it's an objective comparison of the expressive elements between the two works, whereas the intrinsic test kind of asks whether an ordinary reasonable audience would find the two works to have a similar total concept and feel. And so, as I mentioned earlier, the jury returned a verdict in favor of Kat, finding that the tattoo and the original photograph were not substantially similar. The tattoo was transformative in the jury's opinion because Kat had added some shading work to evoke a different perception and a different form of movement in the tattoo that did not exist in the photograph. And also, the court really liked the fact that this tattoo served a totally different and a totally new meaning as a tattoo on Mr. Farmer's arm versus just a copyrighted photograph that Sedlick had. So because the jury found that there was no copyright infringement in this case, the jury didn't even address the issue of fair use. But just as a practical pointer, like I said, this case is pending before the Ninth Circuit. So like Keith said with the previous case, it'll be really interesting to see kind of where the appellate court comes out on this, especially in the aftermath of the Warhol decision, and ultimately shed some light and give some guidance to those folks in the tattoo industry as well for what constitutes fair use and what constitutes infringement.
All right, we are coming up on our time. We just have one more case, and it is a very simple one, but it was potentially important, so we wanted to highlight it. It is a Supreme Court copyright case, and very briefly, the copyright statute says that you have a 3-year statute of limitations for copyright infringement suits. And in this case, Warner Chappell Music versus Neely, the plaintiff filed suit more than 3 years after the infringement began, but relied on what's called the discovery rule, which basically says that if you did not know about the infringement until later, your 3 years effectively starts when you first discovered or reasonably should have discovered the infringement claim. The defendant argued in this case that I guess there was really not much dispute that there was about when the plaintiff made the discovery, but what the defendant wanted to argue was that the 3-year statute of limitations should put a limit on the damages and say, all right, you can file your claim, but you can't go back more than 3 years for damages purposes. This went up through the appeals, and ultimately the Supreme Court said no, a statute of limitations is different than a damages bar. So if you file your claim later, you can catch that whole damages period. Interestingly, it was not discussed whether the discovery rule should even apply to the Copyright Act claims. And a petition for cert has been filed on that issue specifically in another case, Hearst Newspapers v. Martinelli. So we'll see if the Supreme Court grants that one, and if they make a ruling that might change things. It might kind of make this decision irrelevant, but as it stands now, that is the state of the law. And I believe that covers all of the cases we wanted to highlight today. We are 1 minute before the hour, so if anyone has any questions, feel free to pop them into the chat. We would be happy to answer them. You can also, you have our email addresses there. You can follow up with us after the fact. And we'll try to let you all know if we hear any interesting updates from some of the cases that are kind of still working their way through the system.